Hello, everybody. Welcome to third quarter and the start of the judicial branch, the third and final branch of government that we're going to take a look at. First of all, let's look at what is the role of the judicial branch. Okay, and Congress, the legislative branch, passes laws. The president is in charge. The executive branch is in charge of carrying out the laws. Well, the judicial branch interprets the laws in the Constitution. They say they give meaning to laws in the Constitution. Okay, so one of the things that they can do, besides rule in criminal cases, if somebody breaks a federal law, they'll go to federal court through the federal court system. We'll trace cases through that in a couple of minutes. But they also can say whether or not laws passed by Congress or actions by the president or other government officials are in line with the Constitution. And if they're not in line with the Constitution, then they can declare that act or that action unconstitutional. Okay? Now, a few things about the judicial branch, okay? They are independent by design, okay? Any judicial branch appointment in the federal government, they're appointed by the president and they're approved by the Senate, that judge serves a lifetime term, whether they're a trial court judge, a court of appeals judge, or a United States Supreme Court judge. Okay, so they are independent by design. They don't have to worry about getting reelected. In Ohio, our state judges, even our Supreme Court, Ohio State Supreme Court judges, are elected. Okay, so every 3 to 5 to 7 years, they have to run for reelection. Well, when they issue an opinion, or find somebody guilty or not guilty, give out a sentence, they have to worry about, well, what are the voters going to think about this? So they kind of lose a little bit of their independence as a judiciary. Okay, not in the federal court system. They're appointed for life. The only thing that's going to get somebody out of a Supreme Court judgeship or any other federal court judgeship is whether or not if they pass away. You can't be a judge if you're dead, obviously, or they resign. They want to retire, or they can be actually impeached and removed, which several Supreme Court judges over the years have been impeached and removed from power, mainly for bribery. But they don't have to worry about getting reelected. Once they're in their position, as long as they follow the law, and as long as they're alive, they're there for life. Okay? But their interpretation of the Constitution is limited and influenced by the court's composition and the interaction between the citizens and the government. This is called judicial review. Okay, so recently the court has become conservative. For a while, the court was independent. There was a equal number of liberal judges and conservative judges. And when we say liberal and conservative with the judicial branch, we're really not talking about politics. We're talking about legal philosophy, which we'll get to in a little bit. Okay, so a judge, there could be 3 judges that say, oh my gosh, the president's travel ban should be declared unconstitutional. But there might be 6 other judges that say, no, president's travel ban is perfectly legal and constitutional. Well, they went out. There's 9 judges on the court. 6 of those, as long as 5 of those judges rule in favor or against something, they're the majority. So the composition of the court can change, and that changes the interpretation of the Constitution. And then a good example of judicial review is a case called Plessy versus Ferguson, which you guys know that restricted rights. Plessy was a guy, Homer Plessy was a guy that was arrested for he was African-American, and he was in the whites-only train in Louisiana, and it was in New Orleans. And Louisiana law said that train cars had to be segregated. So he refused to give up his seat. This sounds like Rosa Parks, and it's very, very similar. But his case went to the Supreme Court. The Supreme Court said, no, segregation is totally legal under the 14th Amendment because, as long as you get to go on a railroad car, you're being treated equally. Okay, 50 years later in Brown versus the Board of Education, as you know, that Plessy versus Ferguson was overturned. So the composition of the court had changed, and the composition of the court had, there was all new judges on there who had different viewpoints about law and equality and the 14th Amendment. And they said, no, the 14th Amendment says, by nature, separating people by race makes the separation in and of itself is unconstitutional, violates the 14th Amendment's Equal Protection Clause. Okay? There's also limits to the court's power. Even though they serve for life, congressional legislation can change the meaning of a court's decision. Okay, a great example of this is our abortion laws. Okay, the Supreme Court in 1973 said a woman's right to terminate a pregnancy and abortion can't be restricted in the first trimester of pregnancy. Well, they looked at that. Many states and the federal government looked at that and said, well, then maybe in the second and the third trimester, we can regulate it. So congressional legislation changed the interpretation and the meaning of that case. Amendments to the Constitution. We talked about the Dred Scott case, which said that slaves and freed slaves had no rights under the Constitution. That was changed by the 14th Amendment, which says if you're born in the United States, you're a citizen, and if you're a citizen, you have rights under the Constitution. Okay, so that overturned the ruling in that case. Okay, new appointments to the court can change the court's composition and how it interprets the Constitution, which we just talked about. We'll look at the court and how recently, this will be part 2 next week, recently the Supreme Court has taken a conservative turn. That has meaning to the Constitution. Okay? And the presidents in states can flat out ignore, let's be honest, they can flat out ignore what the Supreme Court rules. There is no army that the Supreme Court has to back up their decisions. So what can they use to enforce their decisions? Nothing. So they actually rely on the executive branch to do that. Okay, now let's take a look at the federal court structure. And we'll start at the bottom. Okay, the bottom here, in state court systems and local court systems kind of follow the same structure. Okay, but this is just the federal court structure. And I guess the first question should be, what makes a case go to a state court or a federal court? And the answer is, if somebody breaks a state law, then they would go through the state court system. If they break a state law and that state law somehow involves the U.S. Constitution, maybe it's a free speech case or something like that, then the federal court system could take up that case. Okay, if somebody breaks a federal law, or something under the Constitution, the U.S. Constitution, they'll go into the federal court system. Okay, so at the bottom there's special courts. There's military courts. So if somebody's in the military, they do a court martial. They have a special court. Those decisions can be appealed. There's tax courts and so forth. So if somebody has not paid their taxes, they go to a special tax court. Those are special courts there. Most federal cases, though, start in the district court. Okay, the district court, there's 94 judicial districts in the United States. And these courts hear trials. So this is what you would see on television or the movies. You've got a jury, you've got witnesses, you've got, the defendant and the prosecutor, and you've got a judge, and, they have people testify, they bring evidence in and so forth. And then the jury gives a decision and the judge gives out the punishment. Okay? There's one judge in a district court. Okay? The next court up, if somebody doesn't like the decision against them, they can appeal their case. In that case, it would go to the United States Courts of Appeals. There's 12 regional circuits, and there's one court of appeals for the federal circuit. So that's in Washington, D.C. So there's a total of 13 courts of appeals. There's 3 judges on an appeals court panel. Okay? And the trial isn't redone at the appellate court. What the appellate court does is they have the lawyers from both sides come in and say, tell us about the case. And then they look over the evidence of the case and so forth and the witnesses and the transcripts, and they make a decision. As long as 2 out of the 3 judges rule in favor of one side or the other, that side wins. So you have to win over 2 judges. And finally, a case can go to the United States Supreme Court. The United States Supreme Court has 9 judges. You got to get 5 on your side. It's much harder, first of all, to get a case to the United States Supreme Court. We'll get to that next week. And there's more judges you have to win on your side. And what they do is, I got a video for you to watch in this week's set of assignments. There's 9 judges. They sit on this basically a stage, and the 2 lawyers come forward and they present their side of the argument. And then the judges deliberate and they issue a decision. Okay, and they usually issue a written decision, and it's usually something that written decision is 40 or 50 pages. Okay, the reason they do that is because the cases that the Supreme Court in the United States take are the really, really important, groundbreaking constitutional cases. 99% of the cases that are appealed to the Supreme Court of the United States are rejected by the Supreme Court of the United States. They hear 1 to 2% of the cases that are appealed to them all the time. So they take the really, really important cases. We'll get to that more next week. Okay? Now, this is how the whole system works. Okay? So district court, you hear your trial. The Court of Appeals can take a case to look over a trial to make sure that everything was fair and so forth and issue an opinion, and then it can go to the United States Supreme Court. Okay? From the state, as long as, the states have district courts as well, where they have a trial, they have courts of appeals, and each state has a Supreme Court. But there could be one extra step in a state case. So in a state case, if that case involves a federal question, a federal law, part of the Constitution, an action by somebody in the federal government, then the Supreme Court, the United States Supreme Court, can hear that case. They have jurisdiction to hear that case. Okay? Now, let me go back. We did most of this. Structure of the Constitution, the federal government is set up by the structure of the judicial branch is set up by the Constitution. All federal judges serve for life and are nominated by the president and confirmed by the Senate. They can be impeached. Each of these courts have jurisdiction. Jurisdiction is the right of a court to hear a case, and it's normally through either geography. If you commit a crime in Ohio, Ohio will hear your case. If you commit a crime in Indiana court system will hear your case. If you commit a federal crime, the federal court system will come into play there. Okay, so that's all jurisdiction. Okay, in order for the federal government, the federal court system to have jurisdiction, there has to be a federal law or a U.S. constitutional issue. These are justiciable disputes. That's how you say that, justiciable disputes. Okay, if it's not a justiciable dispute, it's hard to say, then the case is dismissed, which is what happened when Trump's lawyers were disputing the election. They went to court, they went to state courts, and they went through federal court. And almost all of those cases were dismissed because there wasn't a justiciable dispute. Okay, there wasn't any evidence that there was voter fraud. Okay, courts can hear a civil or a criminal case. Okay, a criminal case, somebody breaks a law. Usually the punishment is prison or some kind of suspended sentence or community service, or somebody's put on probation. If somebody doesn't have an attorney or can't afford one will be appointed to them, and you have a right to a jury in a criminal case. Okay? There's also civil lawsuits. Okay? One side says, I was wronged by this side, and they sue in court. It's a lawsuit. Punishment is usually money. Okay? There's no guarantee of an attorney. You have to bring your own attorney. One will not be appointed for you. That's only in criminal cases. And sometimes there's not a jury. It depends on the case and how much somebody is suing for. Okay? All right, now you can see here we've got, I don't know, it's hard to see because it's dim, but you can see, look at Texas down here. See this border right here? This is a district court in Texas. Okay? And it's the Western District of Texas. That's a district court. So if somebody broke a federal law here in this area, their case would be heard by the federal district court there. Where you see the numbers, those are where the courts of appeals are centered. So if somebody breaks a law here, they're convicted and they want to appeal their case, then their case will go to the Fifth Circuit, right here, Court of Appeals. That's probably somewhere in, no, that's not New Orleans. Somewhere in, I can't tell if that's Louisiana or Texas. But anyway, the Sixth Circuit Court of Appeals is in Cincinnati, Ohio. So anything that is within, this area here, all of those cases will be appealed and heard by the 3 judges in the district court of the 6th District Court, which is in Cincinnati, centered in Cincinnati. Okay, there's 94 district courts, 768 judges. They hear trials and decide cases. They have original jurisdiction. Original jurisdiction means that's where the case starts. That's where you have your lawyers and your evidence and your trial and so forth. Okay, there's 13 appeals courts. There's 12 plus the one in the District of Columbia that hears only the federal government's cases. There's a 3-judge panel. They have appellate jurisdiction, appeal. Okay, they don't hear the original case. They only hear appeals. They can only review cases decided by the district courts, cases that are brought to them, appeal to them, and they can reject those appeals if they want to. Okay, and then finally you have the United States Supreme Court, which is located in Washington, D.C. Okay, and that's a special court, which we'll talk about next week. Okay, original jurisdiction, just a review of that, which we just talked about. That's the trial court, concurrent jurisdiction. Sometimes you have a choice of courts. You can go to federal or state court. Depends. Maybe you broke a state law, but it involves a federal issue, freedom of speech. Do you start that case in a federal court or a state court? Well, that's really not up to you. That's up to the prosecuting attorney. Okay, and then there's appellate jurisdiction, an appeal. Okay, that includes the Court of Appeals and the Supreme Court of the United States. Okay, this video, I'm not going to play it for you. I got a link to it in this week's information. It's a CNN video. It's pretty short. It's just a few minutes long, 4 or 5 minutes long, and it takes you inside the Supreme Court. I want you to take a look at that just to see what the court looks like. Okay? Okay, now I'm going to stop here because part 2 is going to be the Supreme Court, and you'll look at that next week.